Good morning, and welcome to this presentation on LGBT rights in the workplace. This presentation is put on by Pro Bono Partnership of Atlanta, and the mission of Pro Bono Partnership is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits that are in need of legal services. If you're interested in becoming a client of Pro Bono Partnership of Atlanta, you'll need to meet certain guidelines which are listed on this slide. You can also find additional information on the website at www.pbpatl.org. The website also has a bunch of other webinars on legal topics that may be relevant to your organization. Today's webinar presents general guidelines for nonprofit organizations, but it should not be considered legal advice. If your organization has a particular issue or problem that you need addressed, you should retain an attorney or reach out to Pro Bono Partnership to see if you can become a client. My name is Catherine Smallwood, and I'm a Labor and Employment Associate at Seyfarth Shaw, which is a law firm that has 13 offices around the world and a great labor and employment practice. And today I'm going to be talking to you about LGBT employees and their rights. I wanted to provide a little bit of background on LGBT employees and the general population in the United States. We don't know the exact number of LGBT citizens in the United States, but one study puts an estimate at 3.5%, which is about 9 million Americans. And the law and the culture around LGBT employees has been changing a lot in recent years. And one interesting statistic is that 91% of Fortune 500 companies now have policies that prohibit discrimination on the basis of sexual orientation. And another 61% have policies that prohibit discrimination on the basis of gender identity. Another interesting thing to consider as an employer is that one recent study found that LGBT employees who perceive that their workplace is unwelcoming can have a loss of engagement of up to 30%. There's some interesting statistics for Georgia employers as well, which will be a big focus of our presentation today. Now, similarly, about 3.5% of employees in Georgia are LGBT, and that translates to about 150,000 employees who work in non-governmental jobs in Georgia who are LGBT, so it's a significant piece of the workforce here in the state. We're going to focus on four main areas today. That is discrimination and harassment, bathroom access, dress code policies, and employee benefits. So turning first to discrimination and harassment, the law surrounding discrimination and harassment comes from many different sources. There are laws at the federal level, the state level, and even at the local level from counties and cities. And we'll talk about all three levels today, but we'll start with federal law. And the big takeaway at the federal level is that there is currently no federal statute that contains the words gender identity or sexual orientation in terms of prohibiting discrimination against workers who are LGBT. Now, the reason I say on the slide that there's no statute explicitly prohibiting discrimination is because there are federal laws that have been interpreted to prohibit this type of discrimination. And we'll talk about that in a little more detail in a couple of slides. But before we move on, I do want to note that President Obama has issued a couple of executive orders that do make it illegal to discriminate against LGBT employees if you're a federal contractor. So if for any reason your organization does any type of contract work with the federal government, you want to make yourself aware of those executive orders and ensure that you're complying with them. I also want to point out that there are a couple of potential changes at the federal level. Since the mid-90s, Congress has considered a couple different pieces of legislation that go towards discrimination or harassment of LGBT employees. And that started in the mid-90s with the Employment Non-Discrimination Act. It's been introduced several times and it's never passed. But more recently, in July of 2015, several U.S. senators and representatives introduced a bill known as the Equality Act. Now, the goal of the Equality Act would be to amend a law called the Civil Rights Act and Title VII of that act. The way that act currently stands, it prohibits discrimination against employees based on a number of protected characteristics such as their racial background, their national origin, their gender, their genetic information, and we'll get into the details of that law a little bit more later in the presentation. But for now, what you need to know is that the Equality Act would amend that law to specifically include gender identity and sexual orientation as protected characteristics. The popular opinion at this point is that that law does not have a good chance of passing given the current makeup of Congress. However, I point it out to you because it's part of an ongoing trend of legislation that's been introduced over and over again. And considering the massive changes that have gone on with LGBT citizens in America, it would not be shocking if there were changes at the federal level in the future. So as an employer, it's something that you want to stay abreast of and make sure you know what the current state of the law is. So earlier I mentioned that the law at the federal level has been interpreted to protect LGBT workers, and that has come through what's known as the U.S. Equal Employment Opportunity Commission, also called the EEOC. Some of you may be familiar with this agency already, but just to provide a little primer, the EEOC is responsible for enforcing federal laws that make it illegal to discriminate against both job applicants and employees because of the employee or applicant's race, color, religion, sex, national origin, age, disability, or genetic information. And for our purposes, the key characteristic in that list is sex, because the EEOC has issued opinions stating that it believes that sex as a protected characteristic includes sexual orientation and gender identity. And we'll get into some specifics of those opinions from the EEOC in just a moment. But I want to point out that most employers who have 15 or more employees will be subject to the EEOC's authority, and the EEOC has the authority to investigate charges of discrimination against employers who are covered by the law. So starting back in 2012, the EEOC has been issuing opinions that really back up the fact that it's made LGBT employees a focus of its investigatory authority. And they've really been going after employers that they see are discriminating against LGBT workers. And that started all the way back in 2012 with a case called Macy v. Holder. And that case involved a transgender employee who believed that he had been discriminated against. And the employee brought a claim in front of the EEOC, which then issued an opinion stating that under its interpretation of the Civil Rights Act, transgender employees were protected from discrimination by employers. Now, the important thing to note about the EEOC's opinion is that because the opinion comes from an agency and not a federal court, the opinion is not necessarily binding on a court of law. So this doesn't mean that the federal court has to follow what the EEOC has said. But it's still important for employers because it means that if you, as an employer, have an employee who goes to the EEOC and files a charge of discrimination, you cannot count on the fact that the EEOC would dismiss that charge and say that the LGBT employee is not protected. Following these opinions issued by the EEOC, that is no longer an avenue that an employer can take in its arguments in response to such a claim. Now, more recently, in 2015, the EEOC had a victory in this area of the law. They were actually able to secure a settlement agreement with a Florida eye clinic after the clinic fired a transgender employee. And the background of this case is that the clinic hired a male employee who then began the process of transitioning to a female. She informed her employer that she was transitioning and she began to come to work dressed as a woman, wearing makeup, things like that. The clinic ultimately fired this employee and she filed a charge of discrimination with the EEOC. The EEOC pursued the claim and was able to get the clinic to agree to a settlement with a very significant payment, and under the terms of the settlement, the clinic has to pay the former employee $150,000, They also have to draft new employment discrimination policies that protect transgender employees, and they have to train their employees on those policies. And what's really striking about this particular settlement is that it comes out of a state, Florida, which does not have strong state law protections for LGBT workers. And that should be a real point of focus for employees in states like that, including Georgia. The Southeast, as a rule, at the state level, does not have many laws that protect LGBT workers. Nonetheless, the EEOC was able to come into the state in this instance and secure this settlement for the employee. And so employers in these states have to be aware that even if you're not bound by a particularly protective state law, you are still vulnerable to having the EEOC come after you with a charge of discrimination. And so you still have some potential for liability no matter what your state law says. So with that, I'll conclude our discussion about the federal level laws protecting LGBT workers. And I want to turn now to state level laws because I think that case provides a good transition into this area. And you'll see on this slide that employers are really dealing with a patchwork of different laws around the country. There's very little consistency from state to state in terms of what sorts of protections LGBT workers are entitled to. And what may stick out to you if you're a Georgia employer is that Georgia is part of a wide swath of white states there in the middle on the color coding, which means that Georgia, like many states in the Southeast, does not have any statewide law that protects LGBT employees. However, as I mentioned, that doesn't mean you're scot-free if you're an employer, because not only are you dealing with federal level enforcement, but there are also local laws that can impact what you have to do with respect to your LGBT workers. And the next couple of slides cover that topic. I won't go into detail of the local laws around the country because we don't have time for that in today's presentation. But this map will give you a good sense of, again, the wide level of variation from state to state, from city to city, and from county to county when it comes to protections for LGBT workers. And again, focusing in on Georgia, what might jump out at you is that there is some level of local protection for LGBT workers in Georgia, and we'll talk about that in just a moment. And the next slide shows the same thing, local laws, except that it's focused on local laws geared towards sexual orientation, whereas the first slide is geared toward local laws addressing gender identity. So there are some slight differences, not too many, but I wanted to include both slides for your own purposes. So let's talk about the local laws at the Georgia level. The main one is going to be the city of Atlanta. I've mentioned on this slide that while there are some counties in Georgia that have protections for public employees who are LGBT, there aren't any counties at this point that are protecting privately employed LGBT workers. However, the city of Atlanta has passed a law that has very wide-ranging protections for LGBT citizens. And the reason I say citizens and not just employees is that the city law covers a multitude of situations, including housing, public accommodations, treatment of customers. But what we're going to focus on today for our purposes is the portion of the law that covers employer-employee relationships. And the city law applies to any Atlanta employer that has 10 or more employees. So it's going to cover most employers, including small businesses and small nonprofits. On the next couple of slides, I've provided a list of the different areas the law touches, along with citations. Now, the nice thing about this law is that you can find a copy of the text online. It's publicly available and free. So because of the length, I haven't included it in the slides, but you can access it easily online with these citations. And they're covered on these two slides. So focusing in on the employment piece of the Atlanta law, I mentioned that it applies to any employer that has 10 or more employees. And the way the law works is that the city has set up the Human Relations Commission. And the Human Relations Commission is tasked with eliminating unlawful discrimination against privately employed LGBT employees. And An employee who feels that they've been discriminated against based on their LGBT status has a couple of options. One option is they can bring their claim before the commission. A second option is that they can file a lawsuit in municipal court. So there's multiple ways that they can go, and that's something you'll want to be aware of. If they go the route of filing a claim before the commission, then the commission has the authority to conduct investigations, hold fact-finding hearings, and try to facilitate a resolution of the parties' dispute. If the commission is unable to have a settlement agreement reached between the parties, then the commission can recommend a solution to the mayor. And before we flip to the next slide, I'll just mention what's interesting about the Human Relations Commission is that its decisions are not very well publicized, unfortunately. So it's not been clear since its beginning how much power it really has. You may recall reading in the news back in the early 2000s that there was a case before the commission in which two members of the Druid Hills Golf Club filed a complaint because they felt they were being discriminated against on the basis of their sexual orientation. At that time, members of the golf club could get certain benefits for their spouses, and these two members who were gay wanted their spouses to receive the same member benefits at the club. The club denied their request. They brought a complaint to the Human Relations Commission, and it found that the club had violated the city law and suggested a punishment to then Mayor Franklin. After initially deciding that the club would not be punished, the mayor fined the club $90,000. Well, the club turned around and sued the city, and at that time you'll recall that the law in Georgia was that marriage could only be between a man and a woman. So ultimately, after a lot of contentious fighting over this case, the state legislature stepped in and said that the club couldn't be punished because of the state law, and that its decision was in line with state law saying that gay marriage could not be legally recognized in Georgia. What's interesting about that is that the Supreme Court has recently decided, and we'll talk about this more in a moment, that gay marriage is legal and is protected by the Constitution in all 50 states. So it's not clear whether that particular case would come out differently in today's legal environment. But regardless of the Commission's power, this is a law that's on the books. It's something that you need to be aware of as an employer and ensure that you're complying with its provisions. So you'll want to take the time to familiarize yourself with it and make sure that your policies are in line with what city law requires. So that wraps up our discussion of discrimination and harassment laws. There's a lot more detail we could go into, but we want to talk about some other topics as well. And I will take questions on this either now or at the end of the presentation if anyone has any. But we will also move on and talk about bathroom access, which is our next topic. So bathroom access is a bit of a hot topic right now. There's been a lot of changes in the legal guidance that's been issued on this topic just within the past year. And this is a topic that you might expect affects primarily transgender employees. So earlier this year, the Department of Labor's Occupational Safety and Health Administration, which you've probably heard referred to as OSHA, it's the same organization that investigates health issues and safety issues in the workplace. Well, OSHA came out earlier this year and issued guidance for employees on the issue of bathroom access for transgender employees. And what this guidance says is that employees who are transgender should be allowed to have access to the bathroom that corresponds to their gender identity rather than their physical gender if there is a difference between the two. And what's important about this guidance is that they say that the employee is not required to provide the employer with evidence of any type of medical procedure or legal change of name before having access to the bathroom that corresponds to their gender identity. And this is in line with some recent EEOC opinions that have come out on this topic as well. Just this year, again in April, so a very recent decision, the EEOC ruled that a transgender employee cannot be denied access to the restrooms used by other employees that share that employee's gender identity, regardless of whether that employee has had any type of medical procedure. And that was a case called, I'll talk about in a little more detail before we move on to dress code policies, that was a case called Lusardi. And in Lusardi, if I can find it in my notes here because I've gotten a little bit behind, but I'll flip ahead. In Lusardi, there was an employee who was a male transitioning to become a female, and the employee had been using a unisex bathroom at the employer's place of business. And that had been the agreement between the employee and the employer. Um, they had stated that the employee would continue to use the unisex bathroom until the employee completed his gender reassignment surgery. Well, ultimately, the employee began using the female bathroom facilities before completing gender reassignment therapy, and that caused some tension with the employer. The employee was scolded for this choice multiple times, and ultimately, the employee was terminated. The employee brought a claim to the EEOC, and they sided with the employee, finding that the employer had violated the Civil Rights Act by discriminating against the employee on the basis of her sex. Alright, so now we've talked about bathroom access, and I want to turn to another issue that affects transgender workers, and that's dress code policies. Now, obviously, if you have a transgender employee that's transitioning from male to female or female to male, the clothing that they're wearing, along with their appearance, the length of their hair, the type of makeup they may wear, may be changing along with their transition. And this can be a difficult issue for employers who have gender-specific dress code policies that may have differing requirements for what can be worn based on whether the employee is male or female. Now, back in the late 1980s, the Supreme Court issued an opinion in a case called Price Waterhouse v. Hopkins. And the takeaway from this opinion was that under federal law, employers cannot discriminate against their employees on the basis that the employee fails to live up to a gender stereotype. So, in other words, as an employer, you cannot fire a female employee because you don't think she's feminine enough, or you can't refuse a promotion to a male employee because you don't think he's macho enough. And that was really the thrust of Price Waterhouse. And in the years since that opinion came out, the federal courts have been hearing cases related to transgender employees and trying to figure out how exactly Price Waterhouse applies to those situations, because when an employee is not simply less feminine or less male, but is transitioning to a new gender identity, it takes it to a new level. And courts have gone different ways around the country on this. Um, but the key case for you to be aware of here in Georgia is a case called Glenn v. Brumley. And that case was decided by the 11th Circuit Court of Appeals. And that's important because the 11th Circuit Court of Appeals is the court that's in charge of federal law in Georgia, Florida, and Alabama. So what they say pretty much goes in the state of Georgia unless there's a Supreme Court opinion that reverses what they've held. And in 2011, this case, Glenn v. Brumley, came before the 11th Circuit, and it involved a state government employee, so it was a public employee, not a private employee. But this employee was hired as a male, eventually transitioned to female, and was fired from her state government job. She sued the employer and ultimately won her case in front of the 11th Circuit. And the 11th Circuit looked at the Price Waterhouse opinion from the Supreme Court and said, we interpret this to mean that you cannot fire an employee or discriminate against an employee because they're failing to live up to the stereotype you associate with their original gender by transitioning to a new gender. And that includes failing to live up to that stereotype through their dress, their hair, or the makeup that they wear. And this is a pretty big decision and somewhat surprising in this part of the country, but it's still good law in the 11th Circuit. And this is a rapidly evolving area of law. I've listed another opinion here called Creed v. Family Express just because this is a case out of the Northern District of Indiana, not the focus of what we're talking about today geographically, but this is a case that went the exact opposite direction, where the court said, we've looked at Price Waterhouse and we don't think it applies to this situation where there is a transgender employee transitioning to a different gender and changing the way that we dress. We think that as long as you have a neutral dress code policy you can apply it even to transgender employees, and that's not discrimination. So I point that out to show you that this area of the law is far from being settled, and the Supreme Court has not weighed in on this exact topic, and so we don't know what they would say. But what we do know at this point is that under the current 11th Circuit law, you cannot discriminate against an employee who is transitioning from male to female or vice versa and changing the way that they dress. Now, I will point out one caveat to that point is that the Glenn v. Brumley case involved a public employee, not a private employee, and it involved a claim under the Equal Protection Act and not Title VII, which is the law that you usually see these lawsuits under. So there were a few differences there, but it's very possible that a private employee could get the same opinion from the 11th Circuit under a similar set of facts because the reasoning would likely be the same. So as an employer in Georgia, that's a case you want to be aware of and make sure that your policies are in line with that opinion. All right, so we've talked about discrimination and harassment, we've talked about bathroom access, and we've talked about dress code policies. And I'm going to turn now to our last topic, which is employee benefits policies. And again, like most of what we've talked about today, this is a rapidly evolving area of the law, and there have been a lot of changes in this area just this year, and they're still really unraveling as we speak. Um, you may have heard that there's been a lot of coverage in the press about the Supreme Court's recent decisions involving gay marriage. The first one was in a case called United States v. Windsor, which was decided in June of 2013. And that case really involved federal benefits for same-sex couples, so it was somewhat limited in its application. Then, this past June, in Obergefell v. Hodges, the Supreme Court went wider and ruled that same-sex marriage is legal and protected in all 50 states of the United States. And obviously, we're only a few months out from this ruling, and so states are still adjusting to this, and employers are still figuring out what this means for their employee benefits policy. And these rulings really have a huge impact on what you can and cannot do in terms of benefits for your employees and their spouses. So the key takeaway from these two cases for employers is that if you offer health or retirement benefits to your employees' spouses, you must now recognize same-sex spouses in the same way that you do heterosexual spouses for the purpose of these benefits plans. So in other words, you can't offer one set of benefits to the spouse of a heterosexual employee and offer a different set of benefits to the spouse of a gay employee. Now, this gets a little bit technical, and I'm not going to go into a lot of detail when it comes to the tax implications of these opinions, but I will touch on it because it's an important topic that employers need to consider, especially Georgia employers, because Georgia previously had a law in place stating that marriage was only between a man and a woman. And that meant that there could be differences between how income taxes for same-sex couples are treated at the federal level versus the state level. Now that the law has changed and gay marriage is legal in all 50 states, that means that the tax implications have also changed at the state level. And the states have come out, and I'll turn to the next slide for this point. The states have come out with different advice and guidance on how same-sex couples and their employers can handle state-level income taxes. Georgia has come out with some guidance recently, but it's not very detailed. I've provided a link to it within the presentation on the next slide, which we'll flip to in a minute if you want to review it yourself. Doesn't provide a whole lot of detail or helpful guidance, but it is there for employees to look at, and it's something that you'll want to consider when you're dealing with tax issues for your employees here in the state. But focusing back on the benefits policies for a moment, we talked about the fact that you'll have to offer the same coverage to same-sex couples, and I talk about that in a little more detail on this slide. Employers who have self-insured plans are not required to provide coverage to same-sex spouses, and that's still the case even after the Supreme Court's recent decision. However, there's a really big however to this issue, and that is that you face a very real risk of a discrimination lawsuit if you're providing differing coverage, even if you're entitled to. At this point, it's sort of a risky proposition to do that. So to the extent that you have a self-insured plan, that's something that you may want to get some more legal advice on and take some time to consider your policy there. And as I mentioned, this next slide talks about the guidance that's been rolling out state by state following the Supreme Court's decision in June. And we've got the link to the Georgia guidance there so you can access it at your convenience. Another issue in the benefits arena following the Supreme Court's decision in June is benefits under the Family Medical Leave Act. You're probably familiar with this if your organization is big enough to be covered by this law, but it essentially grants employees certain rights to take leave, both for themselves but also for family members of certain categories that are ill and need assistance. So the big takeaway following the Supreme Court's decision is that same-sex couples now have the same rights under the Family Medical Leave Act as heterosexual married couples. So to the extent that you have a Family Medical Leave Act policy that addresses leave for married employees, you'll want to make sure that it's updated and make sure that it's in line with the Supreme Court's recent decision. And if you have any other leave policies that go to an employee's right to take leave for a spouse, you'll also want to review those policies and make sure that they are in line and complying with the Supreme Court's decision so that heterosexual employees that are married and homosexual employees that are married are being treated the same under your policies. So that wraps up our discussion of these 4 topics, and I want to leave you with some practical tips. You should review your existing non-discrimination and anti-harassment policies to make sure that you're complying with your state and local law. For many of you, that will mean reviewing the Atlanta law and making sure that your policies are in line with its requirements for employers. You'll also want to look at any gender-based dress code policies that you have and make sure that you are complying with the 11th Circuit precedent on that issue. You'll want to review your benefits policies to ensure that you're treating same-sex couples the same as male-female couples under your benefits policies. And if you have any restroom issues, you'll want to look at your policies or your procedures there and make sure that you're in line with the recent guidance that's been issued by OSHA and the EEOC. And finally, and this probably seems a little bit obvious after our discussion, you'll need to keep tabs on this area of the law. Many of the decisions and the guidance that we've talked about today were issued just this year, some of them just a few months ago. So this really is an area of the law that is changing every day. It's changing very rapidly, and we're almost certain to see more changes coming down the line in the future. So because of this, and because of the fact that employers are still facing a patchwork of different laws from city to city and county to county and state to state, you want to make sure that you're in compliance in every location that your organization is operating. So that wraps up our presentation, and I will stop and see if there are any questions. So the question was, to what extent should organizations be training their managers and employees about LGBT issues in the workplace? I think it's crucially important to provide some training on this for your employees. If you get into a situation as an employer where you've been accused of discrimination against an LGBT employee, and you cannot show that you've trained your employers, your managers, and your employees on the policies that you have in place, what that means is that even if you have protective policies for LGBT workers, they won't help you much in the litigation unless you can show not only were they on our books, but we've also trained our managers on them and expected our managers to follow these policies. So to the extent that you're relying on any policy you have for protection, it's absolutely crucial to make sure that you're implementing it, that you're training it, and that you're ensuring that your managers are following that policy. Yeah. So that is a tough issue, and it's certainly one that could very well come up in our state. So one of the laws I talked about at the beginning of the presentation was, yes, sorry, let me repeat the question. The question was, if you have an employee that needs some sort of accommodation because of their sexual orientation or their gender identity, what should you do if you have another employee with some sort of religious objection to that accommodation? This is a very real issue, and I can certainly see it coming up here in our state. So one of the laws that I talked about earlier was the Civil Rights Act of 1964, and specifically Title VII of that act. And that's the law that when I talked about the EEOC coming in and pursuing claims of discrimination on behalf of LGBT workers, they're doing that under the auspice of the Civil Rights Act. And the Civil Rights Act does have certain provisions that deal with religious accommodation and religious beliefs. And I don't want to get too much in the details of that because it can really vary based on the details of the situation. But that is out there. And to the extent that the EEOC is pursuing a claim of discrimination based on sexual orientation or gender identity under Title VII of the Civil Rights Act, they are also subject to the provisions that are there for religious reasons. Um, if you're just looking at it from a policy standpoint, again, I think it's going to depend very heavily on the situation. You know, not every religiously based objection is going to allow you or enable you to stop providing the accommodation. So it's very fact specific, and to the extent that you're concerned that may come up in your organization, it's something you should probably reach out to an attorney and get a fact specific analysis of. So hopefully that helps and at least lets you know that that provision of the law is out there and does come into play. All right, well, thank you so much for your time.